New Mexico Real Estate Basics, page 28. What are the brokerage agreements between the brokerage and consumers? A brokerage agreement sets forth the rights and obligations of both parties and generally includes an agreement for broker compensation. These agreements are entered into by the brokerage with sellers, buyers, tenants, and landlords. The rules are the same whether the real estate is residential, commercial, industrial, or special purpose. What are the various brokerage employment agreements with consumers? A seller hires a broker under a listing agreement. An agreement between a broker and a buyer is a buyer brokerage agreement. A management agreement is a contract between a property owner and the broker who is hired to manage the rental property. Even if an affiliate associate broker negotiates the agreement, the contract is still between the consumer and the broker. It is important to remember that the brokerage relationship disclosure merely acknowledges disclosure. The aforementioned agreements address the brokerage relationship chosen, exclusivity, and compensation issues. What are exclusive listings? Exclusive right to sell listing agreements give brokerage firms the exclusive right to market the seller's property and receive a commission during the term of the listing, regardless of which person sells it, including the owner. A variation is the exclusive agency listing, in which the owner of the property promises to compensate the broker for locating a buyer, but the owner reserves the right to produce the buyer without paying the broker a commission. New Mexico statutes state that the listing agreement must clearly state if the agreement is an exclusive agency or an exclusive right to sell. What is a net listing, and can New Mexico brokers take net listings? A net listing is an agreement that specifies a net sale price to be received by the owner, with the excess over that price to be received by the broker as commission. This situation presents a potential conflict of interest for the broker. Often, the seller realizes the true value of the property only when an offer to purchase is obtained. Because of the possibility of a conflict of interest between the broker-client relationship and the broker's profit motive, the taking of a net listing should be done with great care and with full disclosure. What specifically must a listing agreement include? To have legal recognition, all listing contracts in New Mexico must be written. The listing agreement should properly identify the property and the terms and conditions under which the property is to be sold. Specifically, the listing agreement should include the listing price and the commission to be paid. The signatures of all parties are required, and a definite expiration date is required on all exclusive listings, as stated in 3.C.6, the agreement. Page 29. Must specify exclusivity. Brokers are required to give a legal or legible copy of the agreement to the owner as soon as reasonably practicable after the listing agreement has been signed by the owner. At what time may a listing broker place a for sale sign on the property? It is illegal to place a sign on any property offering it for sale, rent, or lease without the owner's consent. Thus, the broker may place the sign whenever the seller agrees. Many brokerages include specific authorization for a for sale sign as part of the listing agreement. Who or what determines the brokerage fee? Any commission or fee in any brokerage agreement is fully negotiable among the parties to that brokerage agreement. The listing contract must spell out the broker's commission rate. It can be either a percentage of the sale or a flat fee. The seller in the listing contract may authorize the listing company to share compensation with other brokers, including a buyer's agent solely representing the buyer. Once the parties to a brokerage agreement agree on the structure of the commission, no party other than the listing broker is allowed to alter or attempt to alter the commission arrangement without prior written consent of the seller and the listing broker. What is procuring cause? Procuring cause in a real estate transaction means that the broker started or caused the chain of events that resulted in the sale of a listed property. Procuring cause disputes generally occur between cooperative brokers and are normally settled by arbitration through local boards or associations. NMREC specifically does not have jurisdiction over disputes between brokers as to fees and commissions. Are there any other considerations that may be included in a listing agreement? The agreement should address any reserved items and, if agreed on, a protection clause. In addition, permission must be given for the installation of a lockbox for purposes of ingress and egress, and permission must be obtained to place a for sale sign. Authorization is required if the listing is going to be shared through a multiple listing service. New Mexico law requires all exclusive listings to be written, contain an expiration date, and contain the word exclusive to be valid. Who must sign the listing agreement? To have a valid listing agreement, everyone who has an ownership interest should sign the listing agreement. What is a protection clause, and whom does it protect? At the present time, the use of protection clauses in a brokerage agreement is not specifically addressed in New Mexico law. However, if the broker does include such a clause, it is presumed that the clause would have to be part of the original agreement. The clause would have to include a definite protection time frame.